they were claiming that we were loading trucks. We do it by hand.
Okay.
Basically, our labor is tremendous.
You mean if you're using it to take it off-site, do you mean, or do you mean loading it for purposes
We
of sale?
cannot, yeah, we were under the impression that we can't use a machine
Okay,
to load vehicles.
right. That's what Mr. Johanning said, and he seems to think you are. But let me ask you this, are you delivering large quantities of firewood by truck off premises?
From Canton.
That's from Canton, that's the Canton operation?
Yes, sir.
Okay. And the Driscoll truck that shows in the picture here that was allegedly being filled with some type of mulch for Mr. Driscoll's commercial purposes.
Correct.
Do you sell mulch to landscapers for commercial purposes from this site?
We do not.
That's from the Canton
Well,
site?
if we do it by hand.
Okay. You mean you're loading the truck by
Loading the
hand?
truck by hand.
With mulch?
Yes. But if you tell me that you don't want that, we're willing to comply.
I think you shouldn't be doing that, to be
Okay,
frank
well,
about it.
then we can shift that. It's early enough in the spring. He's been the only landscaper that we've sold to, so.
Or maybe it was an emergency, but I don't
I
think on
don't
a
know.
regular
But if
basis that
it's,
should be.
I don't want it to be a deal breaker where a one-time shot thing,
Okay,
second burns me.
I'm sorry, are you asking questions now?
Yeah,
Mr.
just-
Oldfield or Mr.
Mr.
Prondak?
Prondak.
Yes.
I guess, a point of clarification. So, on the first prong of this application, having to do with the sale of the kiln firewood, your statement is that you've never witnessed commercial loading of firewood off of the premises. Is that right?
Correct.
Did I get that right? Okay. And I guess a question for Mr. Johanning or Mr. Rowe. You mentioned something about photos showing trucks, dump trucks, carrying the firewood off premises. Was that ever presented to Mr. Prondak?
Now, you have to answer that up at the microphone here, so.
No, we presented that to this board. Mary, when was that? Was that?
Was that in February? You said you were up on your roof when you observed
No,
this.
no, it was before February. It was before we had snow, so it had to have been January, or it was probably January. Yeah, before, was it December, January? Before we had snow on the ground. And then, February, we're up on our roof, and, I can hear it. I can see the trucks leaving the barn. So, I don't know. I would ask the Oldfields if that happened or not. I saw it.
Okay. No, I appreciate that, because as I read the application before us, it's one for failure to enforce. And to Mr. Prondak's point, as I understood it, he will enforce a violation he witnesses or is made aware of. And I'm just trying to understand where that conversation has been. Where you have witnessed and have documentary proof of violations, have those in fact been presented to Mr. Prondak?
We told him, and we asked what we've seen, and we asked him to inspect, and he came back saying that there are 3 cords of wood in the barn. Now, one dump truck is about, I believe it's 1 cord of wood. So,
Okay.
3 cords of wood, in our opinion, is more than's required for cash and carry, and perhaps you should ask the Oldfields what their business is. I believe that the majority of the wood business is probably delivered to people's homes in the dump trucks, and there aren't a lot of people that go up there. I don't know, maybe they have 40 people that go up there every weekend and buy 10
pieces
sticks
of
of wood. That could be. Somehow I don't know.
What if I were to tell you there was 4,000 people that came up on a weekend? Right.
You'd be a very wealthy man, that's what I'd tell you. You'd be a good business. Mr. Prondak, let me ask you this question. Do you intend to continue periodically to monitor Thayer Nursery for compliance with not only the wood decision or the number of vehicles, but with all of the other conditions that are contained in the board's decisions over the years.
Absolutely.
Okay.
Mr. Leonard, if I could ask a question.
Sure.
My neighbor, Tina Tevens, mentioned to me last week that it just seems wrong that we have to live our lives monitoring our neighbors for compliance with the zoning bylaws. And I asked Mr. Whiteside, what about weekends? What about nights? Like, if there's a light shining in my window from Thayer Nursery, who am I supposed to call? And he said to me, well, maybe the town needs to hire another zoning enforcement officer to take care of off. Are you kidding me? In a town where we're talking about overrides for firefighters and overrides for schools, we're talking about hiring another zoning enforcement officer for off hours. This just doesn't seem right to me. If Thayer Nursery doesn't comply, and John and I have to spend all our lives chasing after trucks to try to get a photograph of firewood, this is not right. Just like Tina Tevens said, we are not living our lives to monitor our neighbors. The shame of it is that we live with constant noise, constant vibration, constant traffic, roads like Hillside Street that are traveled by 18-wheelers. There's no pavement for someone to walk on. The road is in horrendous condition. I checked with Joe Lynch, and he said it could be 20 years before they pave it. Are you kidding me? Are you kidding me? We have to continue to put up with all of this for what?
Well, all while under cease and desist.
Right.
Up a lot of traffic.
But just to wrap this up, I guess I would encourage the board to say, enough is enough. Let's relieve the Oldfields of the obligation to use this plot for this business. Let's let them grow and be tremendously successful in another location, because, as you yourself said, they may have outgrown this lot, and I think they have.
Well, they may have. I think the problem that you face here, in my view, is that these decisions and your appeals to the Superior Court, where you could get judicial enforcement, has taken far too long. And I know how expensive it is to litigate in the Superior Court and the Land Court. And these aren't fun cases in the Superior Court. Judges are not enthusiastically seeking out these types of disputes, but they do have to be decided. And these cases have sat in the Superior Court for years and years without having a hearing. And it's sad. I think that the Land Court is probably a little more technically equipped to deal with issues like this. And so I hope that Judge Shire gives you a fair hearing and some relief. In the Superior Court, did anybody ever consider the possibility of having the Superior Court cases sent to a special master or somebody who's skilled in these matters for hearings?
I guess we're here before you.
Well, you are, but the problem is...
We expect a decision from this board with respect to how much longer, you want to continue with this.
You're not going to get that type of
Well, I
decision
think
from us.
the reason why we're here is we believe that 3 cords of wood.
I understand that, and we're going to address that issue. I agree with you. Those are the issues that are before the Board of Appeals.
And I guess the other thing that I'll say is that, honestly, how do I see it? I think that there's some shenanigans going on with the clerk of the court in the Superior Court, because we had the chief administrative judge give him a call, and suddenly a file gets found that had dropped behind someone's desk. This is all like a parade of nonsense. But, I've got a lot of time, and, we'll just...
So right now, what we've done, all the parties have agreed to put the Superior Court cases on hold
Okay.
until the Land
Until the
Court
Land Court
rules.
deals with it.
Once the Land
Okay.
Court rules, if they rule in our favor, then all the Supreme Court well, I think.
Superior Court.
Superior Court, our case is still in standing. I believe the cases that Thayer has against the town of Milton probably would be dropped. But the case that the town of Milton has against Thayer and we have against Thayer would move forward.
Right, and so, okay, I hear exactly what you're saying. And all of that's helpful. Let me ask this. Is there anybody present tonight who wants to be heard in favor of the enforcement action? And the record indicates there's no such person present. Is there anyone present this evening who wishes to be heard in opposition to the enforcement action? Okay. Is there anybody who wants to be heard on anything that relates to this application? Okay, so there's no such persons present. So with that having been said, I think we'll close the evidence at this hearing and decide this hearing in open session and issue a decision. So, Mrs. King, do you want to be heard first?
I feel that perhaps our decisions that we're relying on for Mr. Prondak to make a decision are perhaps too vague, and they need to be amended, updated, with something very specific, with how much can be stored there, how much can be sold at a time. I don't think we ever said a quarter of a cord is the limit that can be sold out of Milton or not. I think that would be perhaps helpful for you to make a decision on if compliance is met or not, because there's a squishy, fuzzy part in there right now that we can all, reasonable people could disagree on that, and I think that's creating a lot of trauma in the neighborhood, and I would like to be able to have something that was clear cut so people would know if they were in compliance and or out of compliance and what they need to do to fix it, and the neighbors would have some recourse as to what their standard is for having to, put up with A as opposed to B. So I would hope that perhaps we could do something along that line that will ease things into the future. I understand that we're not going to be able to cover all of the matters that have been brought up by Mr. Rowe and Mr. Johanning tonight, because they are not in the request for enforcement. But I think we can at least fix a few things, and I think that we should do that.
Okay, Mr. Elks?
Well, I don't know if I'm equipped to tell you exactly that 1.5 quart is sufficient, but 2 is too much, or anything above a certain line is too little. I read the decision, and it seems to me that the board did what it could, and I'm not sure that we can be more precise. Maybe I'd be glad to hear what my colleagues have to say on that point. But the point is that I took from the board, what is precise is that whatever's stored, whatever that right amount is, it has to be carried away in personal vehicles and loaded by hand. I mean, that seems pretty clear. I mean, that you can monitor. To the extent it's not being loaded into personal vehicles, but commercial vehicles, or mechanized vehicles are being used to load them, I think this can be enforced. I just don't know that in here we can come up with that precise number that says 2 cords is the limit. I don't know what we base that on. So on that point, the request here is for enforcement, and I think I heard Mr. Prondak say that that's what he will do. He will continue to enforce this, and can we give him more precise direction in terms of the amount of firewood to be stored? I don't know. I'd be interested in hearing people's views. I don't know
Well,
that
I think we have to give something, whether it be a range or an absolute cap. I think that I think that would be helpful for all the parties to know where they stand. And clearly, I mean, oftentimes when we give conditions on something, it's worked out between neighbors, and those conditions are working, and that's great. And they don't have to be any firmer than they were, but it's obviously not working in this case. So I think that we have to be a little more specific
What do you say about the vehicles, Mr. Alves?
Well, I heard that, and this was not controverted, that even if it's inconsistent with Judge Sand's opinion, the operative law, for lack of a better phraseology, the special permit that's in place permits up to 5 vehicles on the property. Now, agreed, that's inconsistent with Judge Sand's decision, but I think there's a legal point there that that special permit, had it been appealed, it could have been reversed. We could have been, Judge Sand's opinion on this case would be sort of the law that's governing what we're talking about here. I guess what Mr. Prondak has to enforce is what the operative standard is. And I think the operative standard that hasn't been controverted is that you're permitted to have up to, I think it's 5 vehicles in that property. I may have misunderstood that, but that's what I took from the evidence I heard.
Mr. Skeen, what do you have to say
Yeah,
about the commercial vehicles, other vehicles?
In as far as, it appears that we really can't change that because it's been there, the statute of limitations has told. So I don't see how we can change that, but I don't want a 6th truck there.
No,
I don't want to stick more there than is already generously given.
Okay. I'll tell you what my view of this is. I think the real issue in my mind is the nursery conducting a commercial firewood sale operation from their premises after the board's decision. And I don't think there's evidence of that, to be frank about it. I think that whether there's 2 cords there, 3 cords there, 5 cords there, isn't really a big issue. I think 3 cords is kind of modest, you know. I wasn't shocked by that. I'm not I don't sell firewood and I don't buy firewood, but it didn't shock me as being an enormous amount. And I guess the problem is that if you say, well, first of all, this is an enforcement action. This is not an action to amend the previous decision of the board. So we're here to say, is Thayer Nursery violating the previous decision of the board? It may not have been the best decision. It may not have been as specific as it should have been. But that's a difficult issue because we were concerned with the concept of what Thayer should be doing. They shouldn't be running a commercial firewood operation from this site. That operation, if they can conduct it profitably, God bless them, should be from some other site, Canton or wherever you have that operation. But we did think that the sale of firewood in small batches, as Mr. Alves said, not to be loaded with bobcats or anything, to be sold to individuals who come to the site, was appropriate and was reasonable and was kind of traditional for nurseries. And the problem is, if you start to micromanage things and you say, well, that can only be 3 cords, well, what if we have a cold winter, as we did, and a lot of people want to buy the firewood from Thayer, and they're buying it at such an extent, I think Mr. Oldfield said that, Mr. Oldfield said that, well, what if 40 people came? Well, he'd run out of firewood, and he'd have to bring in more firewood from Canton, and then you've got, so the kind of a question, is it worse to take a load of 5 cords or 6 cords of firewood, store it in the barn for sale to individuals, as noisy as that may be, or is it better to have 6 deliveries of firewood into the barn? I don't know the answer to that. But I don't think I've heard any evidence that, I'm not shocked by the amount of firewood. I think it's not really the function of the board to decide, as long as there are reasonable amounts there. It's not 50 cords of firewood. It's 3, is it 4, is it 6? I don't know. We're not in the firewood sale business, and that's none. But I think if it's being sold according to the board's direction, then I think that they're not in violation of the order. And I have asked Mr. Prondak specifically whether he was going to continue to monitor the nursery, and he said he was, and I have every confidence that he will. And if he sees a truck there that's being loaded up for commercial purposes, I know he'll stop it on the spot. He'll issue a cease and desist order and notify the board. With respect to the amount of vehicles, I understand Judge Sand's order. It's not an order in this case. Maybe he would have entered in this case, he didn't. If I thought that they were using commercial, loud landscaping equipment on this site, then I would agree with the applicants. I don't think that's the case. They may have, they have 5 vehicles there. I think that's the evidence. I know the decision says 5 vehicles can be there. Maybe a court will say that shouldn't happen under a special permit. It happened many, many years ago. We so decided this. But I think that if there are an extra vehicle or an extra 2 vehicles there, and they're not vehicles that are making loud noises, they're not dump trucks used for construction purposes, I tend to think that that is not a violation of the special permit that's in effect, and I don't think that an enforcement order should issue on that basis. I also think that it's a tragedy that these cases haven't been heard in the Superior Court, that they haven't been consolidated, and if a judge won't hear them, to send them off to a special master, get them decided. But I also think that the land court decision case that Mr. Joe Henning and I think Mr. Rowe probably filed together is probably the right direction to be moving in here, because number one, the land court's very skilled in this area. A lot of Superior Court judges aren't skilled in zoning, and they become concerned if they get involved in 5 or 6 different suits. And I think Judge Shire is a terrific judge, and I think she'll decide this matter hopefully quickly and inexpensively. And if the planning board, as I understand it, will do, is going to issue a decision in June, then that can be dealt with, I think, expeditiously by Judge Shire in the land court in a very intelligent and a very impartial way. And what it does, it gets rid of most of these Superior Court cases, which are going to cost everyone a bloody fortune to both have tried and to appeal. And I'm not sure that the land court can't make a decision that may put an end to a lot of these issues in a far less expensive and in a far more a manner with expertise, and not getting some judge who's been a criminal lawyer all of his life trying to figure out what special permits are and to start to read the history of these decisions and not even know what the cases hold because the decisions have been going on so long. So I understand further that that Mr. Joe Henning has legitimate concerns. I think we've dealt with the Driscoll and the selling of mulch from the site to commercial businesses. I don't think that's appropriate, and I take Mr. Oldfield at his word that that's not going to happen. But if they are selling large amounts of, or selling firewood commercially from this property, I just urge you to take pictures, and I know Mr. Prondak will shut that operation down in an instant, and if he doesn't, we will. I do really understand the agony, I think, that Mr. Joe Henning and Mr. Rowe are going through. A lot of the issues of consternation, forgetting the firewood and forgetting the vehicles, dealing with commercial activities on the site, which you believe is going on. If that's going on, it shouldn't go on. The flooding issue is something that I'm very confident is going to be stopped by the planning board. I mean, it's, nobody's property should be flooded, particularly after the type of excavations that have been taking place. Those are classic cases for injunctive relief. The courts, the decisions are very strict on property emanating on one person's property, and particularly a commercial property, and being allowed to flood out basements or backyards of other homes. I just urge you to keep pursuing that with the planning board, and keep taking pictures of the floodings. It won't harm you at all. That's a very important issue, because it's having a direct physical effect on your property. So on the two issues, I'm inclined not to issue an enforcement order. That's my view of it, and the applicants certainly have their rights to claim an appeal and to add that to the large amount of cases that are still pending in the Superior Court. Mrs. King, what do you want to say?
Well,
I think it's improper to amend a decision of the board that we've rendered. I don't think we have the power to do it in this particular proceeding.
well, that was my question on the procedure of the whole thing, and if we can't do it, you know, I certainly understand that. I would like to be in a position where we could do it, but we're not right now, and so I
at the
understand
present
that.
time. But on the other hand, I would tell you, if there were 100 cords of firewood in there, I would probably say that's ridiculous. I think Mr. Prondak would think it's ridiculous, but whether it's 3, 4, 2, 6, 8, I don't think that's adequate basis to say they're in violation of the special permit. Mr. Alves?
No, I agree. I do think that, and I would encourage Mr. Prondak, as he has indicated he will, to monitor frequently the activities that are going on here. I do think that there's enough in that decision, not to repeat what the chairman just said, but to the extent this is not being sold to individuals and delivered and loaded manually into their personal vehicles, that's in violation of what's in place. I don't want to get in the business of deciding what amount of firewood is appropriate to be held in the property. I'll be brief. I do think that we don't have enough here, in my opinion, to issue an enforcement order. I agree.
But might I add that even loading something by hand can be noisy? I just as a person, I ask you to not have things thrown in the trucks or anything like that. If they're going to be put in by hand, put them in hand. Don't plop them, okay? I think it'll go a long way, Josh, that's all.
It's only the first 20 or 30 pieces, and then...
No, I understand that. It bangs around and stuff, and after that, you've got the wood, and that
Yeah.
makes not so much noise. But
Understood.
given that there's a sensitivity here,
The other
try to
thing,
work with it.
Well, frankly, if you're loading them into trucks, and maybe that's an open question, but that's not a personal vehicle, right?
Pickup trucks.
If everybody has a pickup truck.
Okay, well, I guess I'm talking, okay, if it's going to another business, if in fact loading it onto another landscaping company's trucks, that sort of thing, I think there's sort of the spirit and the sort of
What
the
about Milton
intent-
Academy? They're a
Well-
customer.
let me say one more thing, and
Well,
I think
the decision
the
says-
the decision of the board is going to be, we're not going to
Yeah.
issue an enforcement order here. But my hope is that the decision on the summary judgment matter will help. If the planning board does issue an allowance of a commercial activity on this matter, that will get to Judge Shire immediately. I know you'll bring it immediately. And it would be my hope that if she rules that it's not proper to have a commercial activity like a landscaping business on this property, that you could always seek, this land court and the Superior Court are courts of concurrent jurisdiction, and you could seek an order from Judge Shire or some other judge, Judge Sands or any other judge, to have the cases that are in the Superior Court transferred to the land court, which is a more appropriate venue to have these things heard, and it may bring a quicker decision and a far less expensive way of handling this. than leaving the cases to languish in the Superior Court because nothing's happening there. So I guess the answer is I'm sorry, we're going to reject your request for an enforcement order. I'm very concerned about the other things you did mention. And Mr. Prondak is going to follow up on those and make sure that there's no commercial sales of firewood and that the mulching, sale of mulch to commercial businesses from the site not take place. And I'd further urge Mr. Johanning and Mr. Rowe, as awkward as it may be, but you've been doing it for years now. Now that the snow is gone, continue to monitor, continue to take pictures so that you'll be able to present your case to a court at some appropriate time. So I want to thank everybody for coming tonight and for presenting their views. So all those in favor of issuing an enforcement order on the firewood and on the number of vehicles say aye. All those opposed to issuing an enforcement order say no.
No.
No. Thank you for coming, folks. We hope you get this decided.